Welcome back to the Deep Dive. You know, we spent a lot of time on this show trying to understand the world as it is today. The politics, the technology, the culture, what's coming next. But every now and then, the source material you send us, it forces us to stop and just look at the ground beneath our feet and realize that the history of this planet is, I mean, it's stranger than any fiction we could possibly invent.
It really is. I was reading through the stack for this deep dive, and I kept thinking, if you pitch this as a screenplay to Hollywood,
Right.
a world of, peaceful slime suddenly turning into this world of armored monsters, and all in a geological heartbeat, they tell you the pacing was too fast.
They'd say it was unrealistic. Exactly.
Yeah, no one would buy it.
We are, for all intents and purposes, traveling to another planet today. We don't need a spaceship. We just need to rewind the clock.
What? We're about 538 million years?
Roughly.
Yeah.
We are talking about the Cambrian explosion. And I want to be clear right off the bat, this isn't just a history lesson about old rocks. This is the origin story of, well, everything, us included.
It really is the Big Bang of biology. It's the moment the lights turned on. Before this, Earth was a very different, very quiet place. After this moment, it was loud, dangerous, and recognizable.
So the mission for today is to really unpack this event. We need to figure out why, after billions of years of microbial boredom, life suddenly decided to get complex.
To get big.
To get big and get dangerous.
Yeah.
We're going to meet some creatures that look like hallucinations, and we're going to tackle a mystery that literally kept Charles Darwin awake at night.
Darwin's dilemma. It's a perfect place to start because it frames the stakes of this whole discussion. This wasn't just a curiosity for him. It was a genuine threat to his entire life's work.
Okay, so let's set the scene.
Yeah.
It's 1859. Darwin publishes On the Origin of Species. He proposes this really elegant theory of natural selection evolution by these, creeping incremental changes over vast stretches of time. Use that phrase, natura non facit saltum.
Nature does not jump. That was his mantra. He really viewed life as a ramp.
A smooth, gradual ascent.
Exactly. From simple to complex, you start with a single cell, you get a little cluster of cells, a simple worm, and so on and so on. But when he looked at the geological record, the rocks they had back then, which they called the Silurian, but we now know as the Cambrian, he just hit a brick wall.
He didn't see a ramp, he saw a cliff.
A cliff, a fully formed ecosystem. He saw trilobites. And if you've ever seen a trilobite, even just a picture, these aren't simple blobs.
Not at all.
They have complex segmented bodies. They have this calcified armor. They have intricate eyes, compound eyes like a fly's, and they just appear.
Boom.
Boom. In the lowest layers of rock, they are there. Thousands of them. And below those layers, nothing.
No ancestors.
Oh.
No half-trilobites.
Zero. It's like walking into a mechanic's shop expecting to see nuts and bolts and half-finished frames.
And instead you find a pristine, fully operational Ferrari just sitting in the middle of an empty room.
That is the perfect analogy. And Darwin knew how damaging this was. He devoted a whole section of his book to what he called the imperfection of the geological record. He basically argued, look, the ancestors must be there.
We just haven't found them.
We just haven't found them yet. The fossil record is like a book where most of the pages have been ripped out. We're just missing the earlier chapters.
He was banking on future discovery. The truth is out there, essentially. He believed that the Precambrian seas must have been swarming with life, but for whatever reason, they just weren't preserved.
Exactly. So that leads us to the core question of this deep dive. Was Darwin right? Was the explosion just an illusion, just missing pages? Or did biology actually go nuclear 538 million years ago? Did nature, in fact, jump?
To answer that, we have to look at the before picture. We have to go back further than the Cambrian to a time period Darwin didn't even know existed, the Ediacaran.
The Ediacaran. This is roughly 580 to 543 million years ago.
And looking at the research here, the whole vibe of the Ediacaran is, well, it's distinct, it's alien.
So if I hop in my time machine and go for a swim in the Ediacaran Ocean, what am I seeing? Am I in danger? Am I fighting off sharks?
You are likely the most dangerous thing in that water, by far. The Ediacaran Ocean is often called the Garden of Ediacara. It was peaceful.
The Garden of Ediacara?
Yeah. There were no predators, no jaws, no claws. There was no need to run and no need to hide. The descriptions in the papers are fascinating. They talk about range of morphs. Can you visualize that for us?
Sure. Imagine a fern frond, or maybe a quilted air mattress. Now imagine it's alive, but it doesn't have a mouth, it doesn't have a gut, no eyes. It's just this fractal, self-similar shape lying on the seafloor.
Wave fractal. Meaning the pattern repeats itself as you zoom in?
Exactly. It's a very specific modular way of building a body that we just don't see anymore. These creatures, like Dickinsonia, which looked like a flat, oval bath mat, maybe up to a meter long, they were likely osmotrophs.
Osmotrophs. Okay, that's a great word. Let's unpack that.
It just means they absorb nutrients directly through their skin.
So they're just lying there.
Just lying there on the seafloor, soaking up organic carbon from the water or from the microbial mats right underneath them. It was a slow, quiet, two-dimensional world. Life was mostly flat because that's the best way to maximize your surface area for absorption. If you don't have a gut to digest food inside you, you have to do it on your surface.
Sounds kind of pleasant, actually. A world of living pillows just soaking up soup.
Pretty much.
But you mentioned microbial mats. I feel like we breeze past this concept in school, that the substrate, the literal ground, was different then.
Oh, this is crucial. Today, if you go to the beach and step in the water, the sand is loose, right? You sink in a bit. That's because for 500 million years, worms and crabs have been churning it all up. Right. But in the Ediacaran, the seafloor was sealed. It was covered by this thick, leathery skin of bacteria and algae. It was firm.
The mat grounds. It sounds like a sci-fi terrain.
It essentially was. And these mats stabilized the sediment. They prevented oxygen from getting deep into the mud. So the bottom of the ocean was this sharp divide. You had oxygenated water above and toxic, anoxic, sulfurous mud below. And all the Ediacaran creatures sat right on top of that barrier, on the skin of the world.
But the fuse was already burning, right? It wasn't completely static. The notes mention a creature called Kimberella.
Ah, Kimberella, the herald of doom, in a way.
Doom for the pillows.
For the pillows, yes. Kimberella is distinct from the fronds. It looks a bit like a slug, maybe a mollusk. It had a foot. And more importantly, we find it associated with these scratch marks on the mat surface.
Scratch marks. So it wasn't just absorbing, it was scraping.
It was grazing, it was actively feeding, it was moving with intent. And it was bilateral. It had a left side and a right side, a front and a back. This is the blueprint for almost all complex animals today. Kimberella suggests that the animal revolution, the revolution of moving and eating and interacting, was already starting to bubble up beneath the peaceful surface of the garden.
So you have these quiet quilted mattresses and then this one little slug thing dragging itself around, scratching the floor. It's subtle, but it's the beginning of the end for that whole world.
And then around 538.8 million years ago, and I just love the precision of modern dating. The garden collapses, the mats are torn up, the pillows vanish, and the monsters arrive.
We enter the Cambrian, and the best place to witness this change, the ground zero for our understanding of this explosion, is a quarry high in the Canadian Rockies, the Burgess Shale.
This is legendary stuff in paleontology. It was discovered by Charles Walcott back in 1909. The story goes his horse stumbled on a rock.
That's the myth. I prefer to believe the horse was a geologist.
Likely Walcott was just doing some very good field work. But what he found was a Lagerstätte.
A what?
Lagerstätte. It's a German word. It means storage place. And it refers to a fossil site with just exceptional preservation. Usually, fossilization is heavily biased. Bones, teeth, shells, the hard stuff lasts. Soft, squishy bits rot away in days. But in the Burgess Shale, because of a unique set of underwater mudslides and low oxygen chemistry, we got snapshots of the entire animal.
The whole thing.
Eyes, guts, antenna, delicate little legs. We can even sometimes see the contents of their last meal.
Which is so lucky because, as we're about to discuss, the creatures of the Cambrian were weird. And if we only had their shells, we'd have no idea how weird. We might just think they were clams or something.
You're so right. Walcott, the guy who discovered it, he actually missed the weirdness at first. He was a man of his time. He tried to shoehorn all these bizarre fossils into modern categories.
Right, force them into boxes that already exist.
Exactly. He saw a weird shrimp thing and said, okay, that's an annelid worm. He saw a swimming jelly thing and said, that's a sea cucumber. He was trying to force square pegs into round holes because he just assumed that ancient life should fit into our modern boxes.
It wasn't until the 1970s with Harry Whittington and his team at Cambridge that we realized the square pegs were actually like hyperdimensional polygons.
That's a great way to put it. They reopened the files. Whittington, along with his graduate students Derek Briggs and Simon Conway Morris, they started meticulously dissecting these fossils again. And they realized Walcott was wrong. These weren't just simple ancestors of living things. These were weird experimental designs that don't fit anywhere in our modern rulebook.
Okay, let's talk about the mascot of this weirdness, Opabenia. I feel like Opabinia needs its own fan club.
Opabinia regalis. It really is the poster child for evolution is drunk. No, seriously. Whittington presented his reconstruction of this animal at a scientific conference in Oxford in the mid-70s, and the entire room, full of distinguished paleontologists, they burst out laughing.
They thought he was pranking them.
They thought it was a joke. It looked like a Dr. Seuss drawing or something a child would invent. So imagine a creature about 3 inches long, segmented body, swimming lobes along the side. So far, so normal. But the head.
The head is where it all goes off the rails.
It had 5 eyes. 5 mushroom-shaped eyes on stalks, 2 pairs on the side, 1 in the middle. It had 360-degree vision. It could look everywhere at once.
And the snout?
It wasn't a snout. It was a nozzle. A long, flexible proboscis, like a vacuum cleaner hose, sticking out the front. And at the very tip of that hose, a claw. A pair of grasping jaws.
So it's driving around with 5 eyes looking in every direction, and it uses a face hose with a claw to grab food and pass it backwards to its mouth, which is located under its head.
That is correct. And the question became, what is it? Is it an arthropod? A worm? It just broke the taxonomy. It didn't have the jointed legs of an arthropod, but it had the eyes. It was a mosaic. Stephen Jay Gould called this disparity.
Clarify that distinction for me. Diversity versus disparity. That seems like an important nuance.
It's a key insight. Diversity is having lots of species, like, 100 different types of beetles. They're all variations on a theme. They all basically look like beetles. Disparity is having lots of different themes, different fundamental body plans. The Burgess Shale shows us that the Cambrian had incredibly high disparity. Life was experimenting with its basic architecture in a way it never has since. It was the R&D phase of life on Earth. Just throw everything at the wall, see what sticks.
And some of the things that stuck were terrifying. We have to talk about Anomalocurus.
The strange shrimp. This is a classic story of paleontology puzzle solving. For decades, this animal was actually 3 different animals. Walcott found a fossil that looked like a shrimp tail. Another scientist found a fossil that looked like a circular pineapple slice, which they thought was a jellyfish.
Okay.
And someone else found this sort of sponge-like body.
And it turned out they were all parts of the same animal.
Yes. Whittington and Briggs realized the shrimp was actually a grasping claw, a big feeder appendage. The jellyfish was the mouth, a circular camera shutter-like maw, and the sponge was the body. And when you put it all together, you get the T-Rex of the Cambrian, a 2-foot-long predator with swimming flaps, giant stalked eyes, and 2 spiky grasping arms in front of a circular crushing mouth.
2 feet long doesn't sound huge to us, but in a world of inch-long worms and half-inch bugs.
It was a leviathan. It was the first apex predator. It would have glided through the water just looking for prey, and its existence changes everything, because if there is a giant hunter swimming around, you can't just be a soft pillow anymore. You need armor.
This leads us perfectly into the why. We've established the before, the Zodiacaran piece, and the after Cambrian chaos. We've met the characters, but why did the switch flip? Why 538 million years ago? Why not 1 billion years ago?
It's the multi-million-dollar question. And as with most things in complex science, looking for a single silver bullet cause is usually a mistake. It was likely a perfect storm of geological, chemical, and biological triggers all colliding at once.
Let's look at the environmental side first. Oxygen. We hear about oxygen a lot in these origin stories.
Oxygen is the fuel of complexity. You can't run a Ferrari on AA batteries. To build a large, complex body, and specifically to build collagen, which is the protein glue that holds animals together, you need high oxygen levels. And we have pretty good evidence that oxygen levels in the ocean rose past a critical threshold right around this time.
So the engine could finally rev up. Without enough oxygen, you're just stuck being small and slow.
Right. It allows for higher metabolic rates, active swimming, hunting, digestion, all that good stuff. But you also need building materials. And that brings us to something called the Great Unconformity.
This is a geological term I love. It sounds like a generic breakup. It's not you, it's the Great Unconformity.
It really does. It refers to a massive gap in the rock record. There was a period of huge global erosion. The thinking is that tectonic uplift, or maybe the retreat of massive glaciers from the snowball Earth period, was just grinding down continents. This washed gigatons of ions into the ocean, calcium, magnesium, phosphate.
The ocean became a mineral soup.
A mineral soup that was also alkaline. And this matters because if the water is acidic, it's really hard to keep a shell from dissolving. But if the water is saturated with calcium carbonate, biomineralization becomes metabolically cheap. Suddenly, animals could just pull rock out of the water and build armor. They could build skeletons.
So we have the fuel, which is oxygen, and the bricks, which is calcium. But just because you can build a castle doesn't mean you will. You need a motivation, right?
Yeah.
Nature is lazy. It doesn't build a shell unless it needs one.
Exactly. And now enter the biological triggers. The arms race. And specifically, a fascinating theory called the light switch theory by a scientist named Andrew Parker.
This is the one that posits that the evolution of the eye kicked off the explosion.
Pretty much. Think about the Ediacaran again. If you're a predator, but you can only sense things by touch or by smell, the prey can just sit there. You literally have to bump into it to eat it.
A very inefficient way to hunt.
Very. But the moment one animal develops a primitive camera-style eye,
the game is over. The lights turn on.
The predator can see you from across the room. Now, simply existing isn't a survival strategy anymore. You need to hide, you need to run, or you need to be made of stone. This selective pressure forces the prey to evolve hard shells, like the trilobites.
Or to start burrowing.
Exactly. Which then forces the predator to evolve better eyes and crushing jaws, like Anomalocaris.
Oh,
It's a runaway feedback loop.
it makes so much sense. And we actually see this in the fossils, don't we? The notes mention a creature called Cludina.
Yes, Cludina is a tiny, shelly fossil from right at the transition period, and we find them with these perfect little circular holes bored into the side.
Drill holes.
Drill holes. That is the smoking gun of predation. Someone was drilling through the shell to get to the meat inside. The Garden of Ediacara wasn't just replaced, it was eaten.
There's one more trigger I want to touch on, which connects back to the substrate. You called it the agronomic revolution before?
The Cambrian substrate revolution, yeah. Remember those microbial mats? The sealing of the seafloor?
A skin on the world.
Well, when animals started evolving burrowing behaviors, probably to hide from predators or to find food, they destroyed the mats. They churned the mud.
Bioturbation.
Yes. And this did two massive things. One, it oxygenated the sediment, which opened up a whole new 3D world for life to inhabit underground. And two, it released all these nutrients that had been trapped in the mud back into the water column, which fueled plankton blooms, which in turn fed the animals. It was ecosystem engineering on a planetary scale. The worms literally terraformed the Earth.
It's incredible to think that worms just digging holes might be as significant as an asteroid impact in terms of shaping the planet.
Absolutely. They changed the chemistry of the ocean. They changed the physical structure of the seafloor. They created new niches, which allowed for new species. It was a revolution from the bottom up.
So we have the oxygen, the calcium, the eyes, and the worms. It seems like a slam dunk case for a sudden explosion. But, and here's the twist that we promised, there's a growing consensus that maybe the explosion wasn't quite as explosive as it looks.
This brings us right back to Darwin's doubt. Is the explosion real, or is it just that we put on a new pair of glasses?
Glasses being fossilization potential.
Right. Is it the rise of animals or just the rise of fossils? This is the artifact hypothesis.
Because soft things don't fossilize well.
Correct. If the Ediacaran world was full of soft, tiny little worm things, they wouldn't leave fossils. But the moment they evolved shells, because of the calcium surge and the new predators, suddenly they appear in the rock record.
So did the animals just appear, or did they just become visible?
This is where the molecular clock comes in. This is a fascinating bit of forensic science.
It is. It relies on the idea that DNA mutations happen at a roughly constant rate. It's like a metronome. So if you compare the DNA of, say, a human and a fruit fly, and you count the differences and you know the tick rate of the mutations, you can calculate how far back in time our common ancestor lived.
And when they run these clocks, what do they find? They consistently find that the deep divergence, the split between the major animal groups, like the split between us and arthropods, happened way before the Cambrian, maybe 700 or even 800 million years ago.
So the DNA says the animals are old. The rocks say the animals are young.
That's the conflict. And this is usually explained by the long fuse hypothesis. The idea is that the animals were there for hundreds of millions of years, but they were microscopic, or they were soft-bodied larval forms living in the plankton, effectively invisible to the fossil record.
They were there, but they were hiding.
Or they were just very, very small. Then the environmental triggers, the oxygen, the calcium hit, and that fuse hit the powder keg, and they got big and hard, and they did it rapidly.
So it's both. A long, slow buildup of genetic potential, followed by a rapid ecological unleash.
Precisely. It's not an either. It's a story of potential energy just waiting for the right spark.
I also want to mention the senior lips effect from the reading. This felt like a real statistical gut punch to anyone who trusts the fossil record blindly.
It's a sobering concept. It basically says that since fossilization is so rare, the last fossil you find of a species is almost certainly not the last individual that actually lived.
And the first one isn't the first one.
And conversely, the first fossil you find is not the first individual that lived. Things exist for a long time before they get lucky enough to fall into the right kind of mud and turn to stone.
So the sudden appearance of trilobites might just be the moment their population density got high enough to finally get caught in the fossil lottery.
Exactly. It smears the dates. But even with all these caveats, even if there was a long fuse, the consensus is still that the Cambrian was a unique time of rapid innovation. You can't have a long fuse, but the bang was still a bang. The disparity we see in the Burgess Shale, that's real.
I want to circle back to that weirdness before we close, because there's a philosophical point that Stephen Jay Gould made in his book Wonderful Life that I find really haunting. The idea of rewinding the tape.
This is Gould's most famous thought experiment. He looked at the Burgess Shale, at Opabenia, at Wawaxia, at Hallucigenia, and he saw all these disparate body plans. And many of them just died out. They have no living descendants. Opabenia is gone. Anomalocaris is gone.
We don't have five-eyed nozzle beasts today.
I do not. We have arthropods, insects, crabs. We have chordates, us, fish, birds. We have mollusks, clams, squid. And Gould asked, if you could rewind the tape of life to the Cambrian, just start the movie over from 538 million years ago and press play again, would the same winners emerge?
And his argument was no.
He argued for contingency, that survival was largely luck. Maybe a mudslide happened a mile to the left. Maybe the oxygen dropped for a week. Maybe a predator turned left instead of right. If Pikaia, our little worm-like ancestor with the primitive notochord, if it had been in the wrong place at the wrong time and gone extinct, the entire vertebrate lineage never happens.
That is the heavy part. Pikaia is not impressive to look at. It just looks like a confused little eel.
It's tiny, but it had the precursor to a backbone. And if that one lineage gets wiped out in the Cambrian lottery, then no fish, no dinosaurs, no mammals, no humans, no deep dive podcasts.
We might be the intelligent descendants of Opabenia right now, arguing about that weird two-eyed fossil called Pikaia that went extinct. We'd be communicating by waving our nozzles.
A frightening thought, but scientifically plausible under Gould's view. Now, to be fair, not everyone agrees with Gould. Simon Conway Morris, who also worked on the Burgess Shale, he argues for convergence.
That's the idea that evolution inevitably finds the best solutions.
Right. He argues that eyes are a good solution, so eyes will evolve. Intelligence is a good solution, so intelligence will evolve. Even if Pikaia died, something else might have evolved a backbone, because a backbone is a great way to swim and support a body. But even if you believe that, the specific weirdness of the Cambrian shows us just how broad the possibilities were.
It was a moment where the biological rulebook hadn't been written yet. And that brings us to the legacy of this event. Because even though Opabenia is gone, the Cambrian explosion basically set the table for the rest of history.
It did. By the end of the Cambrian, almost every major phylum, the broadest categories of animal life, was established. We haven't really invented a new body plan since then. Nature settled on the winners. And for the last 500 million years, it's just been riffing on those themes.
Just variations on a theme. A slightly better beetle, a slightly smarter ape. But the chassis was built in the Cambrian.
Correct. The blueprint of your body, bilateral symmetry, a head at the front, a gut running through the middle, a nervous system, the pairing of limbs, all of that was codified in the mud of the Cambrian Ocean.
It is just bizarre to think that when we look at ourselves in the mirror, we're looking at a design that was battle-tested against Anomalocaris.
We are the descendants of the survivors, the ones that swam fast enough, burrowed deep enough, or built hard enough shells. We are the legacy of that first great arms race.
So here's the takeaway for you. The world we live in, this green, loud, complex world of animals, is not the default setting for Earth. For about 85% of Earth's history, life meant slime. Life meant quiet mats of bacteria. The Cambrian explosion was that singularity where the universe, on this planet at least, suddenly became aware of itself, started hunting itself, and started seeing itself.
And the fact that we are here to talk about it is a testament to the incredible and incredibly fragile chain of events that started 538 million years ago.
It makes you look at the world differently. Next time you see a worm on the sidewalk or you eat a shrimp cocktail, show a little respect. You're looking at the veterans of the greatest war in biological history.
Couldn't have said it better.
Thanks for taking this deep dive with us. Stay curious, and we'll catch you on the next one. Welcome back to the Deep Dive. Our mission is to take stacks of complex sources, articles, research, historical archives, and give you the ultimate shortcut to fluency. Today, we are undertaking a deep, analytical examination of the International Court of Justice, often called the World Court.
It's an institution that's, well, it's defined by its paradox, really. Our sources detail the ICJ's immense legal authority as the principal judicial organ of the United Nations, a body capable of settling profound legal disputes between sovereign states. Yet, at the same time, we have to grapple with the fundamental operational truth. The court is, functionally powerless when faced with political resistance.
Our goal for you today is not just to understand what the ICJ does, but why it matters, and maybe more importantly, why it often fails to deliver tangible justice despite its position. And before we unpack that tension, we have to clear up the single biggest point of confusion for absolutely everyone.
That's the geographical and functional twin problem in The Hague. You, the listener, need to know this distinction clearly. The International Court of Justice, the ICJ, which we are discussing today, sits in the Peace Palace in The Hague, Netherlands. Its mandate is narrow but powerful, resolving legal disputes exclusively between states.
So, State A versus State B, that's the ICJ.
Correct. It is not the International Criminal Court, the ICC. The ICC is also located in The Hague, but it operates under a different treaty, the Rome Statute, and its function is to prosecute individuals, presidents, warlords, generals, for things like genocide, war crimes, and crimes against humanity.
Got it. So one handles disputes between nations.
And the other handles criminal accountability for individuals. We are focused squarely on the ICJ.
So we're looking at the ultimate global legal referee for sovereign nations. And this isn't some modern invention. This body, established in 1945, is built on decades of prior attempts to create international justice.
That's right. When the ICJ was officially established in June 1945 by the UN Charter, it was. It was succeeding the defunct institution of the League of Nations. It really represented the culmination of a half-century-long quest for global legal order.
And every single one of the 193 UN member states is automatically a party to its statute.
Exactly, which makes its reach potentially universal, even if its actual authority is, well, it's limited.
Okay, let's unpack this. If we're tracing the DNA of the ICJ, we have to go back to the 19th century, right? To the first formal attempts at global dispute resolution.
We begin in 1899 with the Permanent Court of Arbitration, the PCA. This emerged from the Hague Peace Conference, an idea initiated by Tsar Nicholas II. It was a groundbreaking move, establishing a framework for arbitration between states. The core concept here was that legal mechanisms, not just war, could resolve international conflict.
But the name, the Permanent Court of Arbitration, is a little misleading when you compare to the ICJ today, isn't it?
Absolutely. It wasn't a standing court in the modern judicial sense. It did have a permanent bureau, a secretariat to manage logistics, but the judicial element was completely ad hoc.
You mean what, exactly?
Meaning when two states agreed to use the PCA, they appointed arbitrators case by case from a pre-approved pool of experts. There was no standing bench of judges, no inherent continuity of jurisprudence. It was an arbitration mechanism dressed up in a court's clothing.
So it laid the groundwork. It established the idea of a fixed location and a process, but the judges themselves were ephemeral. That structure proved insufficient once the world witnessed the catastrophic outcome of World War I.
Precisely. The staggering human cost of WWI made the need for a standing, permanent, international judicial body. Well, undeniable. This led directly to the creation of the League of Nations, and Article 14 of the League's covenant specifically mandated the establishment of the Permanent Court of International Justice, the PCIJ, in 1920. This was the ICJ's direct parent.
And the PCIJ solved a crucial organizational problem that the PCA hadn't even tried to address. How do you select permanent judges who represent the entire globe?
That was the foundational achievement of the PCIJ. Its statute resolved that really contentious issue of judge selection by establishing a sophisticated electoral process. Judges were elected simultaneously by the League's Council and the Assembly. This ensured that both the great powers and the smaller nations had a say. An electoral mechanism the ICJ still employs today, by the way.
When we look at the legacy of the PCIJ, what are the lasting innovations? The things that defined international law for the next century? Give us the quick hit list, but with some context.
Okay, so there are three major innovations that directly underpin the ICJ. First, the permanence. It was a truly permanent judicial body. It had a permanent registry, standing procedures, all ensuring continuity and consistency in its administration and its jurisprudence.
Which is key for building trust among states.
Right. Exactly. Second, transparency. Its proceedings, the pleadings, the oral arguments, the documentary evidence were largely public. This openness fostered legitimacy, demanding that states articulate their arguments legally and transparently rather than relying on, secret political maneuvers.
And the third point, which our sources highlight as critically important for the development of international law itself.
That's the codification of the sources of law. The PCIJ statute was the first legal document of its kind to explicitly list the sources of law the court would draw upon. These sources, international conventions, international custom, and the general principles of law recognized by civilized nations, were codified in what is now Article 38 of the ICJ statute. They essentially became the authoritative definition of what is international law, a rulebook the world still operates by.
That is foundational. Now, here we hit a fascinating contradiction, the American paradox. The United States was instrumental in drafting this entire legal architecture, yet it never joined the PCIJ.
Why? It's a recurring theme in U.S. history, isn't it? The conflict between internationalist ideals and isolationist political instincts. Despite strong support from 5 successive presidents, Wilson, Harding, Coolidge, Hoover, and Roosevelt, the U.S. Senate never managed to get the required 2/3 majority to ratify the treaty.
Just couldn't get it over the finish line.
Never. Isolationist sentiments, fears of losing sovereignty, a general reluctance to bind the U.S. military and foreign policy to an international tribunal, it all just prevented membership.
So the nation that provided the blueprint for the World Court ended up standing outside, just watching it operate. That political hesitation, that tension between sovereignty and international obligation seems like a perfect foreshadowing of the enforcement issues the ICJ would face later on.
It absolutely is, especially with the U.S. in the 1980s. That failure to join the PCIJ established a precedent that international justice could be designed by great powers, but ultimately rejected by them when it came time to submit to its authority.
The PCIJ, though, was ultimately a casualty of the Second World War.
Yes. It held its final public session in late 1939. By 1945, when the Allied powers met at the San Francisco Conference to create the United Nations, they decided a clean slate was necessary. They opted to dissolve the PCIJ and establish an entirely new court, the International Court of Justice, as a principal organ of the newly formed UN.
But they kept the rulebook.
They did. To preserve judicial continuity, the ICJ statute is based substantially on the PCIJ's. The ICJ took over the judicial infrastructure, even occupying the very same building, the Peace Palace in The Hague. This makes the ICJ the only principal UN organ not located in New York City, which is perhaps fitting given its unique mandate.
The court officially opened its doors in April 1946 and got plunged into a major dispute almost immediately.
Indeed. Its first case was submitted in May 1947, the Corfu Channel case between the United Kingdom and Albania concerning maritime mines and state responsibility. Since its inception, the court has entertained 201 cases as of September 2025, and it conducts all its work, publishes all its judgments, and hears all arguments entirely in its official working languages, English and French.
That sets the historical scene. We now move into what is arguably the most politically fraught aspect of the court, its composition. I mean, how do you select 15 impartial judges that somehow represent the globe without simply becoming pawns of their home nations?
And this is where the tension between law and politics immediately surfaces. The ICJ bench has 15 judges, elected to staggered 9-year terms. The election process is deliberately designed to force a consensus. It requires a majority in both the UN General Assembly and the UN Security Council, voting independently. 5 judges are elected every 3 years to ensure continuity, so you never get a complete turnover.
But the selection isn't purely based on legal merit. The statute imposes a mandate that forces geopolitical consideration.
Precisely. Article 9 is the legal anchor for this political reality. It demands that the judges must represent the main forms of civilization and of the principal legal systems of the world. This has been interpreted, and this is critical, to mean a balance of common law, civil law, socialist law, and Islamic law traditions. You can't staff the bench exclusively with, say, U.S. and French jurists.
And this translates into a deeply political, informal geographic distribution that the UN membership adheres to, even though it's not strictly written down anywhere.
It's an unspoken covenant among nations. Informally, the seats are distributed like this: 5 seats for Western countries, 3 for African states, 2 for Eastern European states, 3 for Asian states, and 2 for Latin American and Caribbean states. This quota system ensures every region has representation.
And this is where the permanent members of the Security Council, the P5, the US, UK, France, China, and Russia, have traditionally exerted their influence, often making sure they always have a seat at the table.
Historically, yes. The P5 have reserved 3 of the Western seats, 1 Asian seat, and 1 Eastern European seat for themselves. This has been the geopolitical norm since 1945. But our sources highlight 2 major recent shifts that suggest global consensus, particularly within the General Assembly, is starting to push back.
Okay, let's discuss the first major crack in that P5 judicial armor.
Yeah.
The UK loss in 2017.
This was seismic. The British judge, Sir Christopher Greenwood, was supported by the Security Council, the powerful body where the UK holds a veto. But he failed to get a majority in the General Assembly, where every nation has 1 vote. In a dramatic display of General Assembly muscle, the seat went to the Indian judge, Dalveer Bhandari, instead.
That's fascinating. So the General Assembly, which the P5 often views as a less important consultative body, actually denied a permanent member their customary seat. That signals a shifting power dynamic, doesn't it?
It signals a profound shift. It was the first time since the court's founding that a P5 member lost its traditional seat. It demonstrates that the informal geographic quota is no longer solely dictated by the Security Council. It means countries outside the P5 can successfully lobby the General Assembly to prioritize emerging regional powers.
And the second shift is even more recent and geographically specific.
Right. Starting in 2024, for the first time in the ICJ's history, there will be no judge from Russia or the Commonwealth of Independent States occupying the Eastern European seat. This loss further underscores that customary seats are not guaranteed. They are subject to the political scrutiny and majority vote of the General Assembly.
Shifting to another aspect of representation, the source material notes the severe lack of gender diversity.
It's a point of serious and warranted criticism. In 77 years, only 5 women have been elected to the court. While the court has made strides in geographical representation, gender representation lags severely behind, raising ongoing concerns about whether the bench truly represents the main forms of civilization if half the world's population is largely excluded.
Now, setting aside the geopolitics of who is elected, what are the rules designed to maintain the judge's impartiality once they're on the bench? Because independence is the cornerstone of justice.
Absolutely. Judges must be of high moral character and qualified for the highest judicial office in their home states. Critically, Articles 16 through 18 impose structural independence. Article 16 strictly prohibits judges from exercising any political or administrative function or engaging in any other professional occupation. They have to be full-time, independent jurists.
And they can't be biased by their past work on a case.
Correct. Article 17 requires independence from prior conflicts of interest, meaning a judge cannot participate in a case where they have previously served as counsel or advocate for one of the parties. Furthermore, a judge can only be dismissed by a unanimous vote of the other members, which makes removal nearly impossible and thus reinforces their independence from political pressure.
But even with these strict rules, the independence of ICJ judges is constantly questioned. And the sources confirm this, pointing to some concerning research about voting patterns.
They do. Research studying judicial decisions has found strong evidence that ICJ judges favor the state that appoints them. And this isn't just an anecdotal observation, it's a measurable pattern. But the critique goes deeper than simple national allegiance.
How so?
The research also found that judges tend to favor states whose wealth level is close to that of the judge's own state, and also favor states whose political system is similar to that of the judge's own state. This suggests that even these highly distinguished jurists are influenced by deeper structural biases.
So when a state brings a case before the World Court, they know going in that if there's a judge from a similarly wealthy, similarly democratic, or similarly autocratic state, that judge is likely to view the case through a sympathetic lens.
It compromises the ideal of pure, objective international law. And this bias is never more transparent than in high-stakes, politically charged cases like the 2022 ruling ordering Russia to suspend military operations in Ukraine, where both the Russian and Chinese judges publicly registered their dissent. They cast votes that align perfectly with their national political interests.
This brings us to the unique and often criticized system of ad hoc judges. You have 15 judges, but for a specific case, you might suddenly have 16 or 17. Why is this compromise necessary?
This is Article 31, and it's perhaps the most obvious compromise between pure judicial impartiality and the political necessity of obtaining state consent. If a state is a party to a contentious case and does not have a judge of its nationality on the bench, it is allowed to select an additional person, an ad hoc judge, to sit for that case only.
If the point of the court is impartiality, why on earth would you allow a clearly partisan appointee into the judicial chamber?
The rationale is, well, it's political persuasion. The system exists to encourage states to submit cases in the first place. The thinking is, if we give them a judicial officer who can participate in deliberations, who can articulate their perspective and ensure they feel the court has truly heard them, they are more likely to agree to jurisdiction.
And more likely to comply with the ruling.
Hopefully. It is the necessary political compromise that sacrifices pure impartiality for consent.
But if the data shows the permanent judges already favor their home country, doesn't introducing a temporary judge explicitly appointed by one party just make the process look rigged?
That's the criticism, exactly. While the ad hoc judge is required to take the same solemn declaration of impartiality as the permanent judges, the reality is they almost invariably vote in favor of the state that appointed them. In a two-party dispute, the two ad hoc judges often cancel each other out, but their presence ensures the political appearance of fairness, which, in international law, is sometimes just as important as the fairness itself.
It seems like the constant theme is that even in the judicial sphere, the ICJ must prioritize obtaining consent over perfect justice. This leads us directly into Section 3, the constraints on the ICJ's operational power.
This section really addresses the core operational constraint. The ICJ is wholly defined by consent. If we connect this to the bigger picture, the court's authority is never inherent. It must always be granted by the sovereign states appearing before it.
Right. Unlike a domestic court, where if you break a law, jurisdiction is compelled, the World Court cannot compel a state to appear. So, jurisdiction in contentious cases, where only states can be parties, is strictly founded upon the consent of the states involved. How do states grant this consent under Article 36? There are 4 foundations.
First, the most straightforward and arguably the most reliable, the compromise, or special agreement. This occurs when a dispute has already arisen and the two states involved explicitly agree to write up an agreement to submit that specific case to the ICJ.
Why is this the most reliable basis for jurisdiction?
Because both parties actively want a legal resolution. They have already made the conscious decision to abide by the outcome. Therefore, compliance with the final judgment is historically much, much higher in these cases.
Okay, what's the second foundation of consent?
Compromissory clauses. These are pre-existing clauses embedded within a binding treaty, say the Vienna Convention on Diplomatic Relations or the Genocide Convention, that stipulate that any future disputes related to that treaty will automatically be referred to the ICJ.
This sounds powerful, but it relies entirely on states honoring that commitment when a crisis actually hits, which, as history shows, they don't always do.
That's the major vulnerability. The sources highlight the Iran hostage crisis as a classic example. The U.S. brought a case against Iran based on a compromissory clause in the Vienna Convention. The ICJ delivered a judgment, but Iran just refused to participate and ignored the ruling. The clause was legally valid, but politically irrelevant in that context.
Which brings us to number 3. The optional clause declaration, sometimes misleadingly called compulsory jurisdiction. I want to take some time on this because this is where the U.S.'s historical resistance is most visible.
This is Article 36(2) jurisdiction. States voluntarily declare that they accept the ICJ's jurisdiction over certain types of disputes with other states that have made similar declarations. It's voluntary because the state chooses to make the declaration, but once made, jurisdiction becomes mandatory for disputes covered by it.
But the word compulsory is highly misleading here because states often attach extensive reservations, right? They effectively give jurisdiction with one hand and take it back with the other.
They do. These reservations are crucial. States often exclude whole categories of disputes like national security, ongoing hostilities, or very commonly disputes over maritime boundaries. They are agreeing to play the game, but only on their terms.
How widespread is this mechanism today?
It's far from universal. As of 2018, only 74 states had an optional clause declaration in force. And critically, among the 5 permanent members of the Security Council, only the United Kingdom maintains one, and even theirs is highly reserved. The U.S. withdrew its acceptance entirely in 1986 after the Nicaragua case.
If the optional clause is so easy to withdraw and so heavily qualified, why do states bother with it at all? Doesn't that make the court's authority here illusory?
It certainly makes it fragile. States maintain these declarations primarily for political optics and to encourage a general respect for the rule of law. It lets them argue for judicial resolution when they are the plaintiff. The moment they anticipate being the defendant in a costly case, however, they can simply withdraw their acceptance, which many have done.
What's the final fourth foundation of jurisdiction?
Article 36(5) jurisdiction, which provides for the continuation of jurisdiction based on declarations made under the old Permanent Court of International Justice statute. It's essentially a bridge mechanism to ensure commitments made to the predecessor court remain valid.
Now, beyond settling the final dispute, the court has the ability to act quickly to preserve the situation while the case is ongoing. This is the incidental jurisdiction dealing with interim measures.
This is Article 41, and it is a powerful tool. These are binding interim measures, essentially the international equivalent of a restraining order or an injunction. They are designed to protect the rights of a party or prevent irreparable harm pending a final judgment. However, the court can only issue these if it is satisfied that prima facie jurisdiction exists, meaning they have to have enough initial evidence to believe they will have the right to hear the final case.
And we saw this power exercised recently with the order for Russia to suspend military operations in Ukraine in 2022. That was an interim measure.
Which, despite being binding, was ultimately ignored, further highlighting the enforcement gap. An excellent point that ties back to the central tension. In addition to contentious cases between states, the court has a second major function, issuing advisory opinions. These are non-binding, but tremendously influential in defining international law.
Who is authorized to request these opinions, and on what grounds?
They can only be requested by specified UN bodies and agencies, primarily the General Assembly or the Security Council, on any legal question. Other UN organs need General Assembly authorization and must restrict the request to legal questions within their scope of activities.
While they don't settle an actual dispute, they carry enormous moral and legal weight. They essentially clarify what the law is for the global community. Our sources highlight a massive ongoing example right now involving climate change that shows the sheer scope of this power.
Yes, the 2025 advisory opinion on state obligations in respect of climate change is one of the most significant actions in the court's history. It was requested by the General Assembly to address crucial, evolving legal questions. What are states' obligations regarding anthropogenic emissions? What are the legal consequences for states that cause significant harm to the climate system?
The scale of the input for this opinion is just staggering. Why is hearing from 99 countries and 12 intergovernmental organizations so unprecedented?
It demonstrates the global consensus that the ICJ is the only authoritative body capable of tackling a legal question of this magnitude. For nearly 100 nations to line up and offer legal arguments, often highly sophisticated, divergent arguments, shows the world views the ICJ as the necessary catalyst for legal definition. Even though the opinion won't be binding, it will provide the legal foundation for future climate negotiations, treaties, and potentially future contentious cases. It defines the goalposts.
That reflects the court's powerful role as the authoritative legal voice, defining international norms. But this leads us to the critical weakness, the major flaw in the entire system, the enforcement gap.
This is the shadow that hangs over every ICJ ruling. Its judgments are legally binding and final on the parties, but the court itself possesses no police power, no army, and no formal enforcement mechanism. Compliance is entirely reliant on the good faith and political calculation of the states involved.
So if a state decides to ignore a binding judgment, the only avenue for recourse is political, taking the issue to the Security Council.
Article 94 of the UN Charter establishes this pathway. If a state doesn't comply, the injured party can bring the matter before the Security Council, which can then make recommendations or decide upon measures to give effect to the judgment.
But this is where the ICJ hits the brick wall of geopolitical reality, the P5 veto. If the judgment is against one of the 5 permanent members or a close ally they wish to protect, they can simply veto the enforcement resolution. The law is nullified by a political act.
And we don't have to speculate about this failure mechanism. We have the classic painful precedent, The Nicaragua case. This case is the prime illustration of the enforcement crisis.
Let's delve into that because it is the ultimate example of a legal victory being politically erased.
Yeah.
What was the core legal finding in 1986?
The case, Nicaragua v. United States, focused on the U.S.'s covert military and paramilitary activities against Nicaragua, including mining harbors and supporting Contra rebels. The ICJ found the United States guilty of breaching customary international law, including the principles of non-intervention and the non-use of force. It explicitly ruled that the U.S. owed reparations to Nicaragua.
A clear, unequivocal legal victory for a small, developing state. What happened next?
The U.S. initially challenged the court's jurisdiction, and then when the court affirmed it, the U.S. just refused to participate further. Crucially, when Nicaragua brought the judgment before the Security Council seeking enforcement under Article 94, the United States used its veto power to block the resolution.
So the U.S. legally lost, but politically won.
Precisely. The outcome had two devastating consequences for the global rule of law. First, the ICJ's judgment was rendered unenforceable by the very mechanism designed to uphold it. Second, the United States subsequently withdrew its acceptance of the ICJ's compulsory jurisdiction under the optional clause entirely. It was a clear statement. We reserve the right to decide when and where we will submit our sovereignty to international judicial review.
If that's the tension, the legal versus the political, what does that mean for a small state like Nicaragua that won the legal fight but lost the political one? What was the final takeaway?
The final takeaway is cynical but crucial. International law matters, but only until it conflicts with the vital national interests of a P5 member. For small states, winning at the ICJ is a powerful moral and legal victory, which they can use in the court of public opinion, but they cannot expect physical compliance if the Security Council gate is locked by a veto.
The sources also point out a tricky conflict of authority between the ICJ and the Security Council, even when it's not a P5 member being judged, as seen in the Pan Am case.
This conflict highlights which body truly holds the trump card. In 1992, Libya asked the ICJ to order provisional measures to stop the U.S. and U.K. from imposing economic sanctions on them, sanctions which had been authorized by the Security Council regarding the Lockerbie bombing suspects. The ICJ ultimately decided it could not issue those measures.
And the legal reasoning was rooted in the UN Charter itself.
It was. Article 103 of the UN Charter is clear. Obligations under the Charter, which includes Security Council resolutions, take precedence over any other treaty obligations. Since the sanctions were authorized by the Security Council, the ICJ was legally bound to defer to its political power.
It is a constant, unavoidable dance between law and the raw exercise of political power. We've seen the rules and the limits. Let's move to Section 4 and look at some specific contentious cases that better illustrate the court's scope and impact.
We have to start with the most notorious enforcement failure we just discussed. The Nicaragua case remains the definitive illustration of how the Security Council bottleneck can nullify a clear legal ruling.
But the ICJ isn't just about conflicts involving superpowers. It plays a critical role in resolving complex issues of sovereignty, boundary disputes, and resource claims between neighboring states that might otherwise lead to armed conflict.
Absolutely. Consider DRC v. Uganda in 2005. The court ruled in favor of the Democratic Republic of Congo, finding that Uganda had violated DRC's sovereignty and ordering payment for lost resources and damage caused during the Second Congo War. This ruling showed the court's ability to tackle severe historical grievances, though again, the payment compliance relies on political will.
How about cases involving treaty breaches between European neighbors?
In 2011, we had North Macedonia v. Greece. This centered on the 1995 Interim Accord, where Greece agreed not to object to North Macedonia's membership in international organizations under its provisional name. The ICJ found that Greece had breached that accord by vetoing North Macedonia's accession to NATO. The court's ruling clarified the specific obligation Greece owed, forcing the political issue back to the negotiating table.
Let's discuss the most high-profile ongoing challenge, Ukraine v. Russia, 2022. This case is particularly instructive because it focuses on the legal pretext for invasion rather than the invasion itself.
This case is a fascinating exercise in legal interpretation. Ukraine argued that Russia was falsely claiming genocide in the Donbas region, misusing the 1948 Genocide Convention as a legal justification or pretext for its special military operation. Ukraine asked the court to rule that no genocide was occurring and that Russia had no legal basis under the convention to invade.
And the court acted swiftly on the requested interim measures.
It did. On March 16, 2022, only weeks after the invasion began, the court ordered Russia to immediately suspend the military operations. This order was passed by a highly significant 13-2 vote, with only the Russian and Chinese judges dissenting.
That interim order was legally binding on Russia under international law. But what is the ultimate practical reality of that ruling?
The reality is that Russia simply ignored it. The military operations continued unabated. The source material is unequivocal. The ICJ cannot enforce it. This case teaches us that while the court can issue the most morally and legally compelling orders, it cannot overcome the political calculus of a determined P5 member. Its power is purely declarative.
The court also isn't afraid to say no, even to states trying to leverage it for political gain. It has dismissed cases where jurisdiction simply did not exist.
A textbook example is the complaint brought by the Federal Republic of Yugoslavia against NATO actions during the Kosovo War in 1999. The ICJ denied jurisdiction, finding that the FRY was not actually a party to the ICJ statute at the time the application was made. Jurisdiction has to be established first.
So when the court does decide a case, what body of law is it actually applying? You mentioned Article 38 of the statute earlier, which codifies the sources of international law.
It applies international law derived from those three core sources: international conventions or treaties, international custom, and the general principles of law. It also relies on judicial decisions and the teachings of highly qualified publicists as subsidiary means for determining rules of law.
It's critical to note, though, the difference between the ICJ and, say, a U.S. or U.K. common law court regarding precedent. The ICJ is not formally bound by stare decisis.
That is a crucial distinction. Article 59 of the statute states that the court's decision binds only the parties to that specific controversy. It's not like the U.S. Supreme Court where every ruling sets a hard, binding precedent. However, in practice, to ensure consistency, the court relies heavily on its own previous decisions, treating them with great respect, even if it is not strictly bound by them.
This entire deep dive has been an exercise in understanding the constraints, the legal ideal versus the political reality.
That's the tension. The ICJ is the authoritative voice on international law between states. It can issue legally binding rulings and is essential for clarifying complex legal norms. However, its practical impact is always subject to the political calculations and, crucially, the veto power of the most powerful member states within the UN Security Council. It is a court that defines global legal obligations without possessing global police power.
And defining those obligations is often its most effective tool, even without enforcement. Take the climate change advisory opinion. Even if it's non-binding, it creates a powerful legal reality that nations must then confront.
It raises the political cost of inaction. Once the ICJ states definitively that a certain level of emissions violates a state's obligations, any state that ignores that ruling is doing so not just against humanitarian consensus, but against the highest legal authority in the world.
That perfectly encapsulates the tension. We've established the court's foundation, the tricky balance of its composition, and its major hurdle: the lack of independent enforcement.
It shows that even the highest court in the world is fundamentally constrained by the consent of the powerful, a reality woven right into the fabric of the UN Charter.
We mentioned earlier that the ICJ statute lists the sources of law the court can apply: treaties, custom, general principles. This means the court must stick rigidly to what the law is, even if the law is imperfect or unjust in a specific circumstance.
Right.
Yet, I wonder, is there any mechanism buried deep in its rulebook that allows it to operate purely on the basis of what is simply right?
You're setting up the final challenge for the learner, aren't you? You're referring to the power to decide a case ex aequo et bono.
Yes. The court is given the freedom, under Article 38 of its statute, to decide a case ex aequo et bono. Translated from Latin, that means out of equality and for the good. It is a radical concept, essentially allowing the court to decide based purely on equity and fairness, even if it falls strictly outside existing legal frameworks, provided the parties agree.
And as of January 2025, the court has never used this provision in its history, not once. States have never granted the ICJ this total authority to act as a court of pure conscience.
Exactly. Given all the political maneuvering, the use of the veto, and the historical lack of independent enforcement that we've discussed, all the compromises the court has to make, what would it take for states, for the collective global community, to finally trust the World Court with the authority to issue a ruling based purely on that ideal of justice, independent of existing law? What kind of global crisis or what kind of political evolution would finally unlock that provision? That is something truly worth thinking about as you reflect on the limits of global law. Welcome back to the Deep Dive, where we take your stack of sources, strip away all the jargon, and, well, turn that information overload into pure distilled insight.
It's good to be here.
Today, we are taking a pretty exhilarating high-altitude journey. We're looking at a concept that is rapidly migrating from the pages of science fiction to, well, industrial engineering reality.
We really are.
Orbital AI infrastructure.
Indeed, we are witnessing what could be the start of the greatest migration of critical computing hardware in human history. I mean, literally moving our most power-hungry infrastructure off the planet entirely.
And the reason for this massive shift, it isn't some desire for, prestige or secrecy. It's actually a shockingly mundane and immediate crisis.
Electricity.
Electricity. When you look at the stack of sources we compiled for this, the message is just unequivocal. Electric power has become the main bottleneck for AI infrastructure here on Earth.
That's right.
It's not the speed of the chips anymore or the genius of the algorithms. It's the fundamental inability of our global power grids to continuously feed these insatiable learning machines.
And what's really critical here and what all the sources underline is the scale and the sheer speed of this shift. Just, 3 or 4 years ago, the conversation was all about Moore's law, transistor density, processing speed.
Right.
Now, the sheer unrelenting thirst of training these large language models, the LLMs, it's paralyzing corporate expansion.
So companies literally can't build data centers fast enough.
They can't find places to build them because these centers demand hundreds of megawatts each, and they are fundamentally straining local, even regional power supplies. The sources frame this as an electricity supply bottleneck. And if it's not solved, and solved fast, it directly threatens the dominance of nations leading the AI race.
So, okay, that defines our mission for this deep dive. We're analyzing the proposals, the powerful drivers, the staggering scale, and of course, the inevitable risks of moving our computing destiny off-world.
We are talking about space-based data centers, orbital AI infrastructure.
So for you listening, let's define that. What are we actually talking about here?
Right. So these are not just, a few servers strapped to a satellite. These are proposed, modular, massive AI data centers. And they're designed to use continuous, high-efficiency, space-based solar power.
And they have a specific target location.
A very specific one. Sun-synchronous orbit, or SSO. And they're often carefully placed right above the dawn-dusk transition zone of the planet.
It sounds incredibly precise. And probably very expensive. Why that exact spot? What is so magical about the dawn-dusk transition?
It's all about elegance. It's the perfect alignment of orbital geometry and energy capture. So imagine the Earth spinning, right?
Okay.
The sun's synchronous orbit is designed so the satellite passes over the same spot on Earth at the same local time every single day. So if you park your solar array right above that boundary where the sun is either always just rising or always just setting.
The Terminator line.
Exactly, the Terminator line. If you're there, you are, by definition, bathed in constant, perpetual sunlight.
So the satellite is basically surfing the twilight zone, and it never, ever dips into the Earth's shadow.
Precisely. Unlike satellites in low Earth orbit, which, they cycle through maybe 45 minutes of sun, 45 minutes of darkness, a well-placed SSO satellite gets its solar efficiency up to nearly 100%. You never experience night.
And that is the single biggest constraint for solar power down here on the ground.
It's the killer.
Okay, that makes perfect sense from an energy perspective. But it still begs the question. This is a colossal undertaking. People have been talking about space solar power for decades. What makes moving millions of pounds of computing hardware viable now?
It's one thing. The single most important enabling factor, the one that shifts this whole conversation from theoretical physics to, engineering practicality.
And that is?
The economic revolution of reusable rockets. The sources are crystal clear on this. Because of the monumental advancements in reusable launch vehicles, systems that can launch, land, and relaunch quickly, the cost per kilogram to orbit has just fallen off a cliff.
So it's finally cheap enough to consider.
It's becoming cost competitive. The huge cost of the launch is finally being offset by the massive operational savings you get from free power and cooling.
Okay, let's unpack that. This shift from, pure theory to something that's about to become reality. Where did this idea even come from?
Well, the deep history of this idea of space-based computing, it actually predates modern AI entirely. Its DNA is really found in those mid-20th century visions for large orbital industrial systems.
So we're talking big, grand sci-fi concepts.
Big concepts, yeah. Orbital manufacturing, things like that. But the main driver was always harvesting energy, the original idea of space-based solar power.
And the sources bring us back to the intellectual architects of that era, people like Isaac Asimov.
Exactly. Asimov, starting back in the 1940s, he popularized these ideas in his technical essays and, of course, in his science fiction. His story Reason had these huge orbital solar power collectors.
And the core motivation for these early thinkers, what was it?
They wanted to exploit the fundamental physics of space, things we see as hostile to life, but that are actually ideal for machines.
Like the vacuum.
The vacuum, yes. Continuous, unfiltered solar energy, the unique thermal environment. They recognized that space offered conditions for power and for thermal management that were just impossible to replicate on Earth, at least not efficiently.
So the theory was there 70 years ago. Fast forward to today. What was the catalyst that took Asimov's dream off the shelf and put it into an actual project plan?
It was a perfect storm, a convergence of a few key 21st century technologies. First, the incredible miniaturization of computing small satellites, high-density chips.
Okay.
Second, that dramatic drop in launch costs we just talked about. And third, you pair all that with the relentless exponential demand for high-performance computing on the ground.
The AI boom.
The AI boom, so smaller, cheaper, faster launch capacity, meets a demand for compute power that is doubling, maybe tripling, every single year.
That sounds like an inflection point.
It is, and it's led governments and private companies to explore these platforms for really practical, modern applications. You know, secure data handling, edge computing, low-latency processing of Earth observation data.
That makes a lot of sense. If a satellite collects petabytes of climate data, why send it all the way back down to Earth?
Exactly. That process introduces delays, it takes up huge bandwidth. Why not just process it in situ, right there in orbit, and beam down only the compressed, actionable insights?
That low latency argument is really compelling, especially for real-time things like disaster response or autonomous systems.
For sure.
But the sources highlight a really critical milestone in 2025, something that proves this isn't just a concept paper anymore.
That's the real turning point. The sources confirm it. In 2025, a company named StarCloud deployed an NVIDIA H100 class system into orbit.
The H100. For you listening, that is the flagship state-of-the-art GPU platform. It powers almost all modern AI training. It is the most sensitive, most expensive, most power-hungry hardware there is.
Right. And putting one of those through the intense vibration and G-forces of a launch, that is a massive engineering feat.
So what did StarCloud achieve with it?
It was a multifaceted achievement. First, it made StarCloud the first company to successfully train a large language model, an LLM, in space.
Wow.
And even more striking, they confirmed they were able to run a functional version of Google Gemini in orbit.
So this basically proves it can be done.
It proves several things. That the hardware can survive the launch, that the power, the cooling, the communications, it all works outside the atmosphere, and that the entire AI training and inference pipeline can actually function in the void of space.
So that 2025 date, that's a line in the sand. It's the moment the race to industrialize orbit officially started. Okay, now we get to the core of it. Why? Why endure the immense headache, the expense, the risk of launching a data center into space? And it all comes back to these irresistible advantages.
It does.
Let's spend some real time on the central driver, the energy boost.
If electricity is the bottleneck, orbit is a near-perfect solution that's just, well, designed by physics. The first, most obvious factor is the raw intensity of the energy available up there.
You mean the sunlight is just stronger?
Exactly. Solar irradiance, the raw power of the sun hitting the panels, is 36% higher in Earth orbit than it is on the surface.
36%. In the world of energy where you're fighting for single-digit gains, 36% isn't just massive. That's a complete game changer.
It is a phenomenal margin. And that's before we even talk about continuity. As we said, you put these platforms in that specific sun-synchronous orbit, tracking the dawn-dusk line.
You get continuous sunlight.
Full output, 24 hours a day, 7 days a week.
So you get a third more power, and you get it nonstop. What does that do to the financials of a data center?
It completely changes the financial model, especially when it comes to battery storage.
Right. On Earth, you need massive batteries for nighttime and cloudy days.
Massive utility-scale battery arrays. They are incredibly expensive. They're heavy. They degrade over time, and they take up a ton of space. By getting 247 solar in orbit, you entirely eliminate the need for billions of dollars in batteries.
So that saving helps pay for the expensive launch.
It helps offset the high initial capex, yes. That's the real economic killer app. It's not just generating power, it's removing the most expensive part of terrestrial solar. And like you said, you also eliminate weather. No clouds, no dust, no storms.
You're creating an off-the-grid ecosystem that doesn't put any load on our fragile terrestrial power grids.
Exactly.
Okay, so that's the power side.
Yeah.
But the second massive pain point for data centers, especially high-density ones, is cooling. AI chips are thermal monsters. Cooling them takes absurd amounts of energy and, critically, water.
Huge quantities of water. And this is another place where the physics of space becomes this really elegant solution. On Earth, you're using vast energy to run chillers, pump liquids, operate huge cooling towers.
All consuming precious resources.
Right. In space, radiative cooling is the dominant force, and it operates with near-perfect efficiency compared to Earth systems.
Let's explain that. How does the vacuum help you get rid of heat?
So radiative cooling relies on a simple principle. Any warm object sheds heat as infrared radiation. In the vacuum of space, there's no air, so you get rid of convection and conduction.
The main ways heat moves around on Earth.
Right, so you have this huge temperature difference between a hot server and the extreme cold of deep space. You just design these massive radiator panels that face away from the sun, and the heat just radiates away into the void.
You're using the universe as your heat sink.
You've got it. And the sources even mention specialized concepts like liquid droplet radiators or LDR.
Okay, that sounds fascinating.
They are. They work by circulating a fluid, sometimes a liquid metal, and then spraying tiny droplets of it into the vacuum. The droplets rapidly shed heat through radiation, and then you capture the cooled droplets.
To maximize the surface area for heat rejection.
Far beyond what a solid radiator can do. So the energy needed for cooling is dramatically reduced. You're relying on fundamental physics, not brute force mechanical chilling.
What's the catch? Is there a limit?
Surface area. It's all about surface area. That's why these structures have to be so vast. And you have to worry about hot spots, so you need intricate heat piping systems. And with LDRs, well, you need incredibly precise fluid systems so you don't just spray your coolant into the void forever.
So it solves one problem but creates a new, very high-stakes fluid mechanics problem.
It's a trade-off, absolutely.
Okay, let's shift from physics to logistics. When you build a data center on Earth, you have zoning laws, land acquisition, environmental impact statements, taxes. It can delay a project for years.
Yeah.
And orbital infrastructure just bypasses all of that. The sources highlight several huge practical benefits. First, scalability. Space is, well, truly the limit. You're not constrained by real estate prices in Northern Virginia.
You're also freeing up land on Earth that could be used for housing or agriculture.
And third, the financial draw. You completely avoid property tax, local utility fees, land use regulations. It's a massive utility operating in an environment with zero municipal or state-level regulatory overhead.
Okay, let me challenge that. Even with reusable rockets, the launch costs are still immense. How can avoiding property tax possibly justify that?
It's a fair question. You're not just offsetting property tax, you are offsetting the total cost of continuous power and continuous cooling, plus the enormous expense of terrestrial battery backup.
It's an operational expense argument.
Exactly. The OpEx of running a terrestrial data center, dominated by power and cooling, it quickly surpasses the CapEx of building it. By eliminating the power bill and slashing the cooling bill, the whole ROI calculation changes. The massive launch cost becomes a one-time investment that's recouped much faster through perpetual, free, high-efficiency energy.
So it's a long-term financial play. That makes it feel less like a fantasy and more like a necessary, financially sound next step for AI growth.
It is a necessary next step, but well, as with any extreme environment, there's a price of admission. We have to confront the harsh realities. Space is hostile, it's unforgiving, and the cost of failure is astronomical.
Literally and figuratively. Okay,
Yeah.
Let's start with the money. The sources explicitly say high launch costs are still a huge constraint. What does that mean for the hardware you're sending up?
It means every single component, from a structural beam to a microchip, has to justify its mass. The initial capital expenditure is just immense, which puts this technology strictly in the hands of the world's wealthiest entities.
And you can't afford to launch cheap parts if it costs millions to replace them.
Exactly. It puts an enormous premium on reliability and density.
So, assuming they can afford the trip, the hardware then has to survive a brutal ascent and then just exist in this high-risk environment forever.
Right. And there's a sequence of stresses. First, the launch itself. It's a violent, high-G, high-vibration environment. You have to meticulously engineer everything so your sensitive GPUs don't just shake apart.
And you have to assemble it in orbit.
Almost entirely with robotics and remote management, linking these massive modules together thousands of kilometers above us. And once it's built, the environment itself is a constant antagonist, specifically radiation.
Right.
The systems are just constantly being bombarded with cosmic rays and solar flares. This can cause long-term degradation, but it can also cause immediate catastrophic failures. The sources specifically warn about single event upsets, or SEUs.
Can you break down what an SEU is for you listening?
Sure. Think of your computer memory as storing information as electrical states, zeros and ones. An SEU happens when a high-energy particle, basically a tiny high-speed bullet from space, slams into a microchip.
And flips a bit.
It deposits just enough charge to flip a single bit from a 0 to a 1, or 1 to a 0. It's a spontaneous, random bit flip.
And that single flip could crash a whole training run, corrupt your data, or introduce a critical error into a calculation.
Precisely. Which means you need specialized, radiation-hardened components, hyper-redundant memory, and elaborate error-checking protocols built into everything. You can't just use off-the-shelf parts.
Which leads directly to the ultimate problem, maintenance. On Earth, if a power supply fails, a technician swaps it out in minutes. What happens in sun-synchronous orbit?
Maintenance, as we know it, is basically impossible. If a server rack fails up there, you're looking at needing advanced robotics for a repair mission, or, more likely, you just let it die and rely on the redundancy you built into the system.
So the whole design philosophy has to change.
It shifts from repairable to disposable, modular, and extremely durable. The electronics, the solar panels, they all have a limited, non-repairable lifespan.
Okay, let's talk systemic threats. The sources mention the catastrophic risk of runaway space debris, the Kessler syndrome. Why is that such a major concern for these AI megaconstellations?
Kessler syndrome describes a scenario where the density of objects in orbit gets so high that one collision triggers a cascading chain reaction.
A domino effect.
A very fast, very destructive domino effect. Two large objects hit, they shatter into thousands of pieces, each one traveling at orbital velocity, and each piece can then destroy another satellite, leading to an exponential increase in debris.
And if you have companies launching modules that represent square miles of solar arrays, you're dramatically increasing the amount of mass in that orbital belt.
You're creating a massive negative externality. Every launch increases the probability of starting that cascade. If it were triggered, it could render key orbits, including that highly desirable SSO path, unusable for centuries.
So what's the solution?
Mandatory, verifiable end-of-life plans. Every single module has to be designed to deorbit itself safely, which, of course, adds more cost and complexity.
And then there are data constraints. The whole point is high-speed AI.
Yeah.
But doesn't being in orbit create a bottleneck for getting data up and down?
It absolutely does. Orbit imposes severe limits on data transfer latency and bandwidth. Training an LLM means moving petabytes of data. Even with advanced microwave links, there's a limit, and the distance creates unavoidable lag.
So things like laser communication are key.
They're essential, but sending petabytes of training data up and down fast enough without any loss is a huge engineering hurdle. You've basically traded the terrestrial power problem for a potentially crippling data transmission problem.
You solve the cooling and power only to face the data transfer problem head on.
It's the new frontier. If you're only using the orbital center for inference, just running the model, the data need is low. But if you're using it for training, that communication link becomes your new bottleneck.
And finally, a big negative externality for science. These massive constellations could severely inhibit observational astronomy.
This is a huge issue. It puts high-tech industry directly against fundamental science. The problem is the sheer size and reflectivity of these structures.
Satellite flares.
Exactly. The huge solar arrays, the radiator panels, they create these bright, moving streaks in the sky. When they pass through the field of view of a ground-based telescope, they just overwhelm the sensitive optics and can ruin an entire night of observation.
It's light pollution, but generated in space.
That's a perfect way to put it. And it also threatens future space-based telescopes. Every new square mile of satellite is another obstacle for deep space viewing. It forces a really critical debate. Do we sacrifice part of our ability to see the universe in order to feed the growth of AI? That's a massive ethical trade-off. And that discussion of risk and scale brings us right to Section 4, understanding just how big this is and who is in this race to space.
Before we name names, we need a concrete metric for you to visualize the scale we're talking about. When we say massive, how big does the power infrastructure actually need to be?
We can use the gigawatt as a metric. The sources provide a really clear visual. To produce 1 gigawatt of power, that's roughly the output of a large nuclear power plant.
Enough to power a small city.
Right. To get that, you would need approximately 1 square mile of solar array in Earth orbit, assuming about 30% cell efficiency.
1 square mile. For perspective, that's like taking Manhattan Central Park, paving it over with solar panels and launching it into orbit. That's hundreds, maybe thousands of heavy lift launches just for the power system.
And that's before you even add the data center modules. It just underscores the monumental engineering challenge. Terrestrial data centers can use hundreds of megawatts each. If the AI industry keeps growing like this, it'll need dozens of gigawatts. We're talking about building orbital structures that will eventually measure tens of square miles.
These will be the largest things humanity has ever built.
By far, requiring fully robotic assembly and maintenance.
So who is actually taking this on? The sources list a who's who of global tech and aerospace. This isn't a startup game.
No, the roster is very instructive. It shows a convergence of launch capacity, hardware expertise, and AI demand. You start with the infrastructure owners, aerospace titans like Blue Origin and SpaceX.
Bezos and Musk.
Right. They have the essential heavy lift launch capacity. Without their reusable rockets, none of this is even remotely economical.
It's the classic dynamic. The people who build the highway are the first to set up towns along it. But we also see the core AI companies getting involved directly.
Precisely. NVIDIA, which makes the crucial H100 GPUs, is keenly involved. They have to make sure their hardware can even operate in this environment. Then you have the major AI developers, OpenAI, for instance.
Jan Altman's company.
Their involvement suggests a strong belief that relying on terrestrial power is just unsustainable for their long-term goals. They need to control their own destiny.
And that destiny requires unlimited power.
Exactly. And then you have the giants, who are both customers and builders. Google is prominent with Project Suncatcher, which is explicitly researching this. And of course, the early mover, StarCloud, who hit that 2025 milestone.
And we're seeing new players like Aetherflux trying to get in on this too.
We are.
The fact that you have aerospace firms, GPU makers, and top AI labs all investing at the same time, it's just a massive shared conviction.
The conviction is that the terrestrial energy bottleneck is a dead end. They are collectively betting the future of information processing on high orbit.
It's the ultimate example of disruptive innovation, but one that's driven purely by necessity.
It is. The capital, the engineering, and the necessity have finally aligned to take that decades-old Asimovian vision and make it a tangible industrial reality.
So as we land this deep dive, let's circle back. We've gone from a theoretical concept from the 1940s to training a massive AI model in space in 2025. And it's all driven by the simple, brutal fact that power on Earth has become unsustainable.
That really is the core takeaway. The scale of AI's energy thirst is pushing the frontier of computing infrastructure higher and higher. But, what happens next is arguably even more disruptive than the servers themselves.
How so?
Well, if the computing centers move to space, the entire network supporting them has to follow, that high-speed orbital data backbone.
Because right now, you still have that crippling latency and bandwidth problem getting data to and from Earth. The data pipeline is the new bottleneck.
Correct. So that bottleneck demands radically new solutions. This orbital infrastructure will rely on, and more importantly, it will drive the development of new communication tech. We're talking about things like high-bandwidth laser communication in space and advanced microwave transmission just for inter-satellite links.
So this isn't just about point-to-point communication. It's about weaving a dedicated space-based data ecosystem.
Exactly. We're seeing the need for things like the space network and near-Earth network to evolve into a global high-capacity mesh. These AI centers will be the key nodes in a network that completely transcends Earth's atmosphere.
And that lays the groundwork for something even bigger.
It lays the critical foundation for the most visionary concept of all, the interplanetary internet.
So what's the final provocative thought we leave with you, the listener? What does the birth of this orbital infrastructure really signal for the future?
I think the real revolution might not just be where the servers sit. It's the creation of a fundamentally new high-speed orbital data backbone, one that's separate from and potentially faster than our existing terrestrial internet.
So we're not just extending the Earth's network into space.
We're building a parallel, solar-powered communication grid in the void. This new orbital network will allow AI to scale, unbound by terrestrial constraints. It could create a separate informational plane that could eventually manage global data transmission, resource allocation, maybe even coordinate interplanetary missions. The next phase of the internet may not be underground or underwater. It might be thousands of kilometers above our heads.
Something for you to mull over the next time you look up at the night sky.